Ladies and gentlemen, we're glad you're here. Welcome to Criminal Justice Full Committee. It's a great day. It is Tuesday, February 13th, 2024, and you are at the House Criminal Justice Committee. Madam Clerk, please take the roll.
Representatives Carringer, Davis, Doggett, Farmer, Fritz, Glenn, Hardaway, Howell, Johnson of Knox, Lamberth, Moody, Russell, Towns, Vice Chair Gillespie, Chairman Hulsey.
Here.
Mr. Chairman, you have a quorum.
Thank you very much. Members, are there any personal orders from anybody? Chairman Moody, you're recognized.
Since it's late in the day, this is an important announcement. Spring training camp open this week, and I'm all about the St. Louis Cardinals. So you'll all notice, if you're a Cub fan, your bill's going to die.
Okay, you heard that threat from the committee. All right. Any other personal orders or threats?
Yep.
Leader Lambert.
Mr. Chairman, a few days ago, we had a deputy shot and killed by an evil individual in this state. And I want to give a public shout out to the Blount County SWAT, the Alcoa SWAT, and the TBI, because they have apprehended that individual, and I hope that he is brought
Good.
to justice. So
Good.
he has been caught, and
Amen.
please do give them a hand and your prayer.
Where did they catch him at?
Mr. Chairman, I can get you that information.
Okay. Was it in Knoxville? Okay. All right. Words of wisdom from Mr. Tyler Muniz.
Good afternoon, ladies and gentlemen. Today's words of wisdom are brought to you from an American legend, an Alabama grad, a Vietnam veteran, a skilled table tennis player, and the owner of Bubba Gump Shrimp, Mr. Forrest Gump. There's only so much fortune a man really needs, and the rest is just for showing off. Y'all have a great day.
And there you have it. Thank you. All right, we're ready to start the calendar. Item number 1 is House Bill 1924 by Butler. Thank you, sir. Is there a motion? I've got a motion and a second. Representative Butler, you're recognized.
Thank you, Chairman and committee. For those of y'all that were in the subcommittee, you'll have to bear with me for just a moment. So I represent Morgan County Correctional Facility in my district, which, by the way, is one of the best prisons in the state. And we have had a continued issue with inmates exposing themselves to correctional officers, especially our female correctional officers and our female staff. And unfortunately, we cannot let these individuals not be held accountable because they're in a prison. They're in a prison because they couldn't make good choices outside of prison. So regardless of that, I think we owe it to our correctional officers to hold these accountable. So this piece of legislation extends an inmate's sentence for 2 weeks after they've gone through due process and have been convicted through a court of law, a jury, if they so chose, or a judge. And so we're not violating anybody's constitutional rights because it's done through due process. The prison themselves has an internal process to investigate. And once they get to this point, it'll be up to a judge or a jury. And I'm gonna give you some examples. So I met with the district attorney back in the fall, and just in Morgan County Correctional, they had a full page of inmates that had exposed themselves, that had either admitted to it or had been internally investigated and determined. And most of those inmates had 1 or 2 infractions, but they had one inmate in particular that was in for carjacking that had committed this and been convicted internally 7 times. And so he's not in there for a sexual related crime, but he is acting out in a sexual way. And so I think that needs to be addressed, not only for the public safety, but for the safety of our correctional officers. And so this legislation just simply extends their sentence once they've been convicted for 2 weeks. And with that, I'll renew my motion and be glad to answer any questions.
Any questions for the sponsor? Chairman Doggett.
Thank you, Mr. Chairman, and thank you for bringing this bill. A couple of years ago, we had a series of hearings with TDOC, and there was one particular inmate that was discussed who had, I believe, somewhere around 17 infractions, and that number may be incorrect, but I was infractions such as this, where this incident had occurred numerous times. And the question that I posed was, why wasn't this person prosecuted for this? Why was this just a disciplinary matter? But I'm hoping that they will take this seriously and it will be prosecuted. We'll have to go through the local district attorney's offices to do this, but this is something that's much needed. Had this one in particular individual had been charged and found guilty on these numerous counts, it would have perhaps prevented an incident that occurred later when they were released out of prison. And so even though these people are not in there for this particular incident, these things do occur and they need to be held accountable for this. And you know, the prison guards, the staff, people are there, they're victims too when this happens. So thank you for bringing this bill.
Representative Johnson.
Yes, again, I wanted to bring up some of the concerns I had. I understand your legislation. And you say 2 weeks, but that is the minimum, right? What is the maximum they could get for this?
Good.
Well, my legislation will only use the 14 days. So
Total.
it'll just be 14 days if properly through due process have been convicted.
Okay, my other question is, I still have constituents who have concerns about, they swear that in their local, that if someone was out without a shirt, they tap them for indecent exposure. And another situation where it's more dorm or barracks-like, where there is no privacy and you pretty much can't help that. What about in those situations?
Thank you, Chairman. This is only going to be effective in our state prisons, the way that this is focused on our state prisons, not on a county jail. So if an inmate has their shirt off or is changing, this is focused on intentionally going up to the window, depending on what level of security they're in, getting the correctional officer's attention, and then doing it. They have had instances in Morgan County where an inmate has been being transported somewhere inside the prison and has done it in the process of being transported. And so my focus is not to do anybody with taking a shirt off or changing. This is focused on people that are continually, intentionally doing this. And I don't think it's fair to our correctional officers to subject them to this and not hold these folks accountable.
No, I understand that is not your focus, but I'm wondering, is that going to be a consequence of this legislation? And I'm also curious, does that put them on the sex offenders list?
Go ahead.
Thank you, Chairman. Right now, the way the process is already set up, they can already be put on the list, the sex offenders list. If it's happened in 3 times in the prison, I believe, if I'm not mistaken, they're already going to be put on the sex registry. That would be in addition to this. Because I think my colleague over here alluded to a situation that we've already dealt with in our state.
Mhm.
This was brought to me by my correctional officers in my prison at the same time this other incident had occurred. And so I think not only the General Assembly realized, but I think our correctional officers and TDOC realized we have a problem here. We need to address this that could potentially eliminate some future problems or maybe a future crime.
Yeah, and I understand that and support that. However, I'm thinking about those lesser circumstances or selective prosecution when it comes to this that I think could be an unintended consequence.
Okay, briefly, 1 second. We need to go out of session. There need to be a clarification here from legal. We're out of session. Legal, go ahead.
Michelle Fogarty, Legal Services. Just to clarify a few points, the bill raises the offense from a Class A misdemeanor to a Class E felony. The punishment for a Class E felony is up to 6 years. The bill requires a minimum mandatory sentence of 14 days to be served consecutive, but they could get up to 6 years. Additionally, removing a T-shirt would not be covered by this offense. It intentionally exposes a person's genitals or buttocks to a guard or staff member. It is limited to a person confined in a penal institution, but a penal institution is defined as any institution or facility used to house or detain a person convicted of a crime, adjudicated delinquent by a juvenile court, who is in direct or indirect custody after lawful arrest, or when such institution or facility is a court-operated long-term residential substance abuse facility.
Representative Johnson.
Lots of questions. So it sounds like, yes, they could get 6 years.
It raises the offense to a Class E felony, and that is punishable by by 1 to 6, anywhere between 1 to 6 years.
And so I want to ask a little bit about that. What you said, so you said anywhere includes jails and juvenile detention as well, correct?
That was within the definition of a penal institution that I just read.
And it also said, there's one more. But I guess those are two really big. It does include jails and more dorm style places. And you said they have to intentionally, but what if you're undressing and you are in a public space? Because some of those places would be public space.
So the elements of the offense are intentionally exposes the person's genitals or buttocks to a guard or staff member or engages in sexual contact, as that is defined as intentionally touching a victim, the defendant, or any other person's intimate parts.
Thanks for the comment.
Okay, any other questions for legal? So that's what the sentence is. You're saying it's a minimum of 14 days that they have to serve. Okay.
Yes, Chairman. That's all we're asking for is the 14 days that they
All
serve.
right, we're back in session. Chairman Doggett.
Thank you, Mr. Chairman. Something I wanted to say earlier, and I failed to do so, and is that sponsor, you said it, there is due process involved, and that what takes place in that is that these charges are presented to the district attorney's office. They're going to look into it, and if the elements of the crime are not there, if they do not meet, they're not going to prosecute. They have that discretion to do so. And so even though this is an enhancement, it is not an automatic. Just because someone says that they have committed this crime, it does not mean that it is automatic. It's going to happen. There is going to be investigation, even further investigation, to make sure the elements of the crime are met. So I just want to get that out there, that there is even discretion with the prosecutors on this.
Representative Davis, I'll get to you, promise. Okay, go ahead.
I just want to, my colleague said it very well. They're not looking at the guy that's done it one time. They're looking at the guy that's done it 7 times. We have limited resources in our district attorney's offices across the state. And so we're not going to waste our effort and time and energy on a guy that's done it one time. He's been there 5 years. We want the guy that's done it 7 times in 3 months. That there's obviously an issue there. And so to address those issues, they do have to go through due process. They do have to do an additional investigation. They do have to have evidence. They have to have all the things that would require out here in the civilian world to prosecute these individuals. So there is a thorough due process. With that, I renew my motion.
Vice Chairman Gillespie.
Thank you, Mr. Chair and sponsor. Thank you for bringing this. This unfortunately does hit very close to home to both myself and my families and my constituents. And I want to just let you know, thank you. Thank you.
Okay, any other question for the sponsor? Question been called on the bill. We're voting on House Bill 1924. All those in favor say aye. All opposed, no. Ayes have it. Moves on to Finance, Ways and Means.
Thank you, committee.
That brings us to item number 2, HJR 0798. It has been rolled 1 week, which now brings us to item number 3, which is House Bill 2053
Second.
by Capley. Got a motion and a second. Representative Capley, you're recognized.
Thank you, Mr. Chairman.
Wait 1 second, please. Chairman Doggett.
Thank you, Mr. Chairman. If you will, let's roll this to the heel of today's calendar, please.
Motion and a second. Roll to the heel. That brings us to number 4, House Bill 1602 by Representative Chisholm. There's a motion and there's a second. We'll wait a second or 2 or 3. Representative Chisholm, you are recognized.
Thank you, Chairman and committee. I have brought to you House Bill 1602, and this bill requires that law enforcement have an audio-visual recording when they were doing a formal interview of a juvenile offender. I'd like to thank the law enforcement, the TBI, as well as the Association of Chiefs of Police for helping us with this legislation, and also thank the members of this committee as well. And with that, I stand back to you all.
Any question for the sponsor? Seeing none, we're voting on House Bill 1602. All those in favor say aye. Opposed, no. Ayes have it. Representative, your bill goes to calendar and rules.
Thank you, Chair and Committee.
That brings us to item number 5, which is House Bill 2030 by Representative Jones. I don't see Representative Jones. We'll roll that to next to the Hill, which brings us to the Hill. There you go. Leader Lambert, you're recognized.
Move previous question.
Previous question has been called for. Is there any objection?
Whoa, don't go nowhere. Don't
We
go
had a
nowhere.
former motion and second. I'm assuming that still stands good. Is that correct? Is there another motion? There's a motion and a second. All right, we're voting on House Bill 2053. All those in favor say aye. Opposed, no. Ayes have it. Your bill passes to calendar and rules. That brings us back to the next to the Hill, House Bill 2030 by Representative Jones. There's a motion, there's a second. Representative Jones, you recognized.
Thank you so much, Mr. Chairman. This is before I proceed, actually, I have the amendment that I wanted to add on to the bill, Mr. Chair.
Is that Amendment 13593?
Yes, that's the correct amendment.
Okay, Amendment 13593. Can you explain the amendment and then we'll vote to put it on?
Yes, so thank you so much. Last week, this bill passed through Criminal Justice Sub unanimously, which kind of expanded Tennessee law for revenge pornography, which was a misdemeanor, to include everything to be a felony. This amendment is to try and, in the spirit of that, to make it more similar to states like Alabama, where the first offense will be a misdemeanor and any subsequent offense will be a felony conviction. That's the basis in states around us, and just wanted to add that as an amendment with the committee's support.
Okay, we had put on Amendment 13377, which made all of them a D felony. You're saying the first offense, your amendment says first offense is a Class A misdemeanor. Is that
A Class
correct?
A misdemeanor, then any subsequent offense will be a Class D felony.
Okay, Leader Lambert.
Thank you, Mr. Chairman, and I've spoken with the sponsor about this. I mean, I prefer them all to be a D, but it's your bill. You're the prime sponsor on it. So, I mean, this is an amendment that I would support. At least a multiple offender would be a D felony. I think I spoke, when it was in subcommittee, I think they all should be D felonies. This is pretty horrendous action. But again, I respect the sponsor's wishes on that a first offense be an A misdemeanor. It would be a bit of a downgrade from what came through sub. And as long as the subcommittee chairman has no objections, it was my amendment in subcommittee, but this one still gets us at least closer to recognizing the severity of this type of ridiculous crime. I mean, it's horrible. I mean, people should not have to go through what they go through now, and it just be a misdemeanor. So at least in the second offense, it would still be a D felony. So I just wanted to speak on it, Mr. Chairman, since it was my amendment that kind of made it a D felony last week. This is still a step in the right direction, though quite not as far as the step we took last week.
Chairman Doggett, you recognize.
Thank you, Mr. Chairman. Mr. Sponsor, an offender has multiple charges on this. Would this kick into that D felony, or would it leave it as multiple misdemeanor charges for the first time?
Go ahead.
Thank you, Mr. Chair. Any subsequent conviction, and so there would have to be a conviction, and then any subsequent conviction would be a Class D felony. And at least that was the intention behind the bill. I'll refer to our legal counsel, but any subsequent conviction would be a Class D felony. And I just want to say that the intention behind the original bill was to add AI, something that just trying to be forward thinking about this issue that I know some students went with. This was just trying to add AI. So the original legislation that was passed by this body was making a misdemeanor. My bill was simply adding AI to be included. Chairman Lambert added on this amendment, and this is now adding amendment to just as almost like a compromise, looking at what Alabama does. Alabama has this tiered system where your first conviction is a misdemeanor, any subsequent conviction is a felony conviction. We have tier punishments here when it comes to things like animal cruelty. The first offense is a misdemeanor, any subsequent offense is a Class D felony. I believe the same is with some forms of stalking as well. But just wanted to again, leave that at the committee's indulgence. To look at this tier type of system as well for this offense.
Chairman Doggett? Okay. Representative Davis?
Thank you, Mr. Chairman. And to the sponsor, I guess my question has to do with a lot of times with regards to this artificial intelligence is that someone has to have a certain mastery or level to be able to do this. And it's incredibly difficult to then detect those folks. And so that's where my concern is that if we have that higher level of a felony, that hopefully that will discourage people, that will be more of a deterrent to do so, because it is very difficult to catch.
Go ahead.
I think the unfortunate thing about the world that we're in now is that this new AI technology does not require expert level knowledge. Like, this is becoming more normalized. And so college students, high school students can use this AI technology. It's becoming that normalized, which is why we see multiple bills in this committee and in this legislature looking at AI when it comes to multiple issues, even in government operation. We just had a bill about AI policies in schools because students have access to this technology. So it's not as far out and requiring expert level mastery as one may think. It's very common technology now, and it's only going to become more normalized as we go forward in our society.
Representative Hardaway?
Thank you, Mr. Chairman. And just to accentuate what the point that the sponsor is making, I have a school, Granville T. Woods, and in fact, some of you have voted for legislation to help them, a charter school. And one of the benefits that AI brings, and seems like it's a double-edged sword, is you don't have to know code. You just have to know how to speak and ask the right questions. You can actually develop programming in just talking English, and AI will take it and convert it to the necessary code. So that's to help the committee to understand it doesn't take super expertise to get some of these things done, and you just know how to ask the right questions and direct the program, and it'll do the devilment. So I understand where the sponsor is coming from.
Okay, I failed to recognize Representative Davis. He had a follow-up question, so you get two questions there for the price of one. So you're recognized.
Thank you. And I appreciate that to the sponsor. So I guess my question then is, if it is easier to then be able to do this, the damage and the harm that it can have on an individual, especially in middle school or high school, that has been their face and image has been plastered in some of these really horrific sort of imagery. Don't we need to make a strong statement that we are trying to discourage and deter this, and discourage it in any form or fashion, that it's very punitive, and to deter folks from doing it, those students especially, because they are looking at things in terms of, it's a prank, or it's a joke, or there's probably a malicious intent behind it, but at the same time, they need to understand the ramifications of their actions and the severity of it.
Right.
That it lasts forever.
There's no disagreement from me that this is a serious issue, which is why I'm the one who's bringing the legislation, because this is an issue that we need to address. And originally, when this legislation was filed around revenge pornography, it was this body who made it a misdemeanor. I was not even a member yet. You were not a member yet. And so when this legislation originally went through, it was made a misdemeanor. My legislation was simply the intent behind it was trying to add AI, which we hadn't talked about, adding AI to this legislation. So there's no disagreement from me that this is a serious issue, which is why I want to add AI to it, because it's a discussion that we need to have. And we have some experts here who can talk about the prevalence and also the dangers of misused AI as we proliferate this in our communities. And so I definitely agree that this is something that we need to take seriously, which is why I have an amendment to base it off of Alabama, another state that is our neighbor to the south, who's taking it seriously and said, we're gonna structure this where the first offense is a misdemeanor and any subsequent offense is a class, in our case, a Class D felony, which is a serious felony. And that was another conversation with Representative Lambert. That's not a Class E felony, but it's a Class D felony, something that is taking it very seriously. For the damage that it does to people. I mean, this is something that we understand is something that we saw recently in the news with Taylor Swift, but also it's happening every day to young women and even children. I know Representative Littleton has a bill about children specifically, but this bill, the intention behind this bill is to add AI to our revenge pornography statute and to make sure that we're living up to a 21st century world. And that's the intention behind the bill. Thank you.
Representative Towns.
Mr. Chairman, thank you. Members, what I hear is that obviously we know this is very serious as it relates to maligning someone's character, image, or what have you. It's very dangerous, and you know, we don't like it. We don't want it to happen. But on the other side, what I'm hearing by assuring that it becomes a misdemeanor, the gravity of the law allows for there possibly to be some redemption for the person who's run afoul of the law. And so what you want, hopefully, in a perfect world, we get the best of two. You know, this person sees they made a mistake, you get a misdemeanor, and they cease and desist that kind of behavior and go on to become productive and do the things that we think and know that they should do. And a person that's been aggrieved also has the gratification and satisfaction of the fact that something was done to that particular individual. And if they are going to be hard-headed, whereas old folk would call them back in the day knuckleheads, they feel the heaviness, the gravity of the law, okay? So I think it's a step in the right direction to let people know we're very serious about it. If you're gonna be a knucklehead and do it again, we're gonna show you exactly what it is by increasing the punishment to that level of felony. So thank you, Mr. Chairman.
Representative Fritz.
Thank you, Mr. Chairman. And I do appreciate you bringing this bill, Representative. Because getting ahead of some of this stuff is going to be difficult for us. My question, and I voted for your bill last week, and I fully support what we're trying to do here. The first element, when I go back and read it, how do we prove that? It's the whole consensual photograph thing. And I think I hope we would all agree that any of this pornography anywhere in our schools, anywhere, is abhorrent and we should not accept it. But my question on this one is how do we prove that first element? It's not at all a question of should we do the AI thing. It's how do we prove that first element?
Okay.
Go ahead.
The first element in regards to revenge pornography or specifically around AI, because the first element is already in statute.
Agree. I understand, but I'm asking that question. If we're doing this, sorry, Mr. Chairman, how do we prove that? When you look at that, how do we bring that to a level of proof? It says agreed upon. So does that mean there's some contract or some agreement, some exchange of payment for the photograph or something like that?
Go ahead.
So the first element, if we look at what this is amending, Tennessee Code annotated section 3917-318A1, one has two parts. Either one, A, the image was photographed or recorded under circumstances where the parties agreed or understood that the image would remain private, or B, the image of an identifiable person was created or modified by means of a computer software program, artificial intelligence application, or other digital editing tools. So that one has two parts. Either it's an agreed upon photo or it's an AI photo. And so that first element does not carry over to AI. As long as it's an identifiable person, was created or modified by means of a computer software. So there's no way to say that you had given someone permission in secret, that this was going to be secret. This AI is adding a whole new subsection B. So it's separate. These are separate issues.
Go ahead.
I understand. I promise I'm not being argumentative. Thank you. It's just that first part is how do we, because we're voting on both of those right now. We're about to vote on what that language is, I think.
We're not,
Yes.
sorry, thank you, Representative Fritz. We're not voting on both of those. We're just voting to add this subsection to it. 1A is already the law. If I can defer to legal, this is already the law of revenge pornography. This is adding on the AI provision onto that. We're not voting on both of these. One of them's already the law. We're just adding another subsection to one.
Go ahead.
I'll withdraw my question. I'm not trying to be argumentative. We are voting on both of those. I understand that. You still have my vote, Representative. It's just a question. So I'll withdraw.
Okay, we're getting close to revenge food deprivation here, so Representative Hardaway.
Thank you.
The amendment, yeah, in just a minute.
Where are we on this, Mr. Chairman? We're on the amendment?
We're on the amendment.
Okay. Has everyone asked all your questions? Mr. Chairman, I think we're ready for the vote.
All right, thank you for that. I appreciate that so much. All right, we are voting on Amendment 13593. All those in favor say aye. All opposed, no. Amendment goes on the bill. If you wish to be recorded as a no, see the clerk. That brings us back to the bill. Any other questions on the sponsor on this lengthy bill? All right, we're voting on House Bill.
Mr. Chair,
I'm sorry. Yes.
because we had witnesses who had come to share their concerns.
Yeah, I didn't think you'd have any problem passing your bill. I thought they were coming to support the bill, and,
Sorry for you.
and so you got a green light here. You ought to stick with it. All right.
Thank you.
All right, House Bill 2030. All those in favor say aye. Opposed, no. Ayes have it. Sir, it goes to Finance, Ways and Means.
Thank you so much.
Thank you.
Thank
I
you,
believe
committee.
that ends the calendar. Are there any other questions? Motion to adjourn. We are adjourned.
Wait, did I just hear everyone?